My name is Joe Thickens. So for the people who are on Zoom, thank you for joining, or GoTo or whatever platform we're on today. Thank you for joining. If you can't hear at some point, you can please just feel free to unmute and let me know. The way we're set up here, I cannot see you on the main screen that's up there, and so we'll just have to have you chime in on that. But otherwise, if you would stay muted so that there's no keyboard chatter or unintentional noise interference, everybody will appreciate that. So we'll go ahead and get started. The topics that we're going to cover today that you probably saw in the email that went out are business contracts and liability protection. So we're going to talk a little bit about contracts for your business and insurance, which will sort of tie in a little bit. Some employment law essentials, best practices for hiring, firing, and employee policies. And then some business structures and compliance. And if we have time, we'll get into intellectual property protection. I have a little bit on that, but that's a pretty technical area of the law. And so we'll address that as we get to it. So this would not be a presentation with a lawyer if there wasn't some fine print. And so here we go on that. I'm a lawyer here in Columbia. My primary area of practice is in personal injury and workers' compensation. I represent people who are injured either at work or doing other things. I have worked, my first job was in a firm where we did some corporate law and also represented businesses through insurance companies. And so I've certainly had some experience in this area of the law. I'm happy to share that. But today I'm primarily speaking to you as a fellow business owner, someone who runs a business like everybody who's on this call. And so my purpose is not to offer legal advice, but rather a perspective about how to think through your risk. And I think that thinking through risk is really something that I'm interested in, because while I represent people who are injured either at work or in accidents elsewhere, which you wouldn't always think of as a business related area of the law, it really does give me a perspective on, man, if somebody had just thought of this accident would have never happened, or they never would have this exposure to liability. And so I would love for nobody to have exposure to liability and everything to be covered and in place so that those things either don't happen or they're completely handled and stress-free when it does. As an example, though, even as a lawyer, I have a law partner we started our firm, Cavanagh and Thickens, in 2017. We hired a business lawyer to draft our LLC documents and our operating agreement. Right, so we're lawyers. We're hiring lawyers. It's like you wouldn't go to your cardiologist if your bone was broken. Right, so we want to have the right person on your team. We had an ethics lawyer review our client contract to make sure that we were doing the things that we needed to with respect to our clients, so that our contract complied with all the rules. We have an insurance agent who focuses not just on insurance, but on errors and omissions policies for entities that owe a fiduciary duty to their clients, like lawyers do, CPAs do. And so we have a succession planner who drafted a buy-sell agreement for us. These are things that we probably could have done. We could have gone on and found a template. We're lawyers, so it probably would have been right, but probably really isn't good enough in these areas. So we're going to talk through how to approach that risk and look at it. All right, so in each topic, there's 4 or 5 topics I told you we're going to cover. I'm going to end with a question that you can ask yourself, and that's where you can really probably focus your attention at the end of those. You're not going to memorize these things. This is more to create a universe of thinking through potential issues. So I'm going to conclude with a question that I hope is a pointed question for you to ask yourself. And if your answer to that question is, oh no, I'm not doing this right, think of that as good news, because you're now on the way to managing your business better, managing your risk better. All right. So we're going to jump right in. This is topic number 1, business contract and liability protection. Also at the end of each topic, I've received some questions by email that I'm going to try to, or by filling out the online document. I'm going to try to tie into those topics. And then at the end, if you have a question and we have some time, I would love to open it up and answer questions. All right, so we're going to talk about business contracts to begin with. Contracts is probably the thing that we got the most questions on for this. It's something that really touches on just about every business. And so we're going to just start off with the the key elements of the contract. This is first day of contracts in law school. You show up, and this is slide number 1. Right. So to form any contract, the elements are an offer, acceptance, meeting of the minds between the party, consideration, capacity, and legality. So offer and acceptance, I think, are pretty clear. You know, I have a service that I provide or goods that I sell. They have agreed to accept that. There's a meeting of the minds, for instance, on the price or the consideration. You know, I'm going to give you X, you're going to pay me Y. Capacity and legality, we're not going to talk about as much, but capacity, that's, you can't contract generally with a minor. Okay, if somebody who's mentally unable to form a contract. And then legality, for instance, we could make a contract right now for you to run a casino down the road for me, but if you stop running the casino, I couldn't go to court and have that enforced. It's not legal to begin with. Okay. All right. So this is small text. I'm going to talk through this. You don't really have to read all of this, but the reason that you want to have a clear contract is to leave as little as chance as possible. All right. A clearly written contract by both parties is going to be the easiest thing for you to enforce it if a dispute arises and to go back to, so that you can prove that this is what was agreed on and this is what we're doing. Non-exhaustive ways. So this is not a complete list of less secure ways to form a contract, but rather than having a written contract, you could, maybe give a quote. I see this a lot. Give a quote to a customer. They don't sign it. It is in writing. It's not signed. What if they change it? A roofer, and I tell them, black shingles on your house for X price. And then we talk about it, and red shingles price. We talk about it. We don't reduce that to writing. Put red shingles on the house, and then they come back and say, well, I wanted black. I have nothing to prove that other than we had a conversation. Okay. So a quote or a change that is not signed by the customer. An invoice sent after you've provided services. That's another common one. So you've cleaned somebody's house. You send them an invoice. They don't pay you. Maybe they said, well, you were only supposed to clean the main level, not the upstairs. How do you prove what was agreed on beforehand so that that's enforceable? And of course, we've all heard of handshake deals. It's really not as uncommon as it sounds. I mean, I can think of many instances, but I have a guy who does my neighbor's yard. I do my own yard for some reason. I just like to get out on my own. But he was doing the yard, and one of my sprinklers was broken. And so I went up to him and asked him, hey, how much would it be for you to fix this? He told me a price. I said, sure. We shook on it. He fixed it. I paid him cash. There's no record of that. I said, well, I didn't tell you to put that in there. He had nothing to go on. If he had fixed it and then told me double the price, I had nothing to go on. But we did it on a handshake. It's easy to do if you're comfortable. It's easy for me to do in my practice. Somebody comes in, I want to look at their case. I may not be ready to sign it up yet. So we have a handshake deal. I'm going to look at this and we'll get back to you. Well, what if I sit on it? What if it's 3 months down the road? I haven't done anything. They come back, want to know what's going on with their file. We have no agreement that reflects what I was going to do, what I said I would do. So you want to avoid getting into those situations. And then oral contracts, even if by accident. So go back to my example with the changing the roof color. If that's not reduced to writing, even a change in a written contract. Some of that is going to be a cost-benefit analysis to you, okay? So it's not always practical to just have a meeting where you sit down at a conference table and sign a contract. It's just not going to happen. For instance, I have a shred company that comes and empties our shred bin every month. I pay them after they do that. We have a services agreement that was agreed on. I pay them after they come do it. If I don't pay them 1 month, they're just not going to come back. We're not going to go to court over the $50, but they're going to fire me as a customer, right? So sometimes it makes sense to invoice after the fact, get paid after the fact. But if that's for $100 service, if we're talking about a $1,000 service, probably going to want to reduce that to writing, or they want to be paid up front. So we're going to talk a little bit about how to accomplish those things. What should be in your contract? So walking back through those terms that we initially talked about, a written contract signed by both parties outlining specific terms. That's going to be your gold standard. That's what really going to want. That can be in the form of a quote that the customer then countersigns. So maybe you use quotes for your business. That's as simple as having the quote, giving it to the customer, and then having them, sign a copy and you have a card. That's so much better than just giving them that and trusting that they're going to follow through on the performance. Same thing with an invoice. Maybe we're looking at invoicing someone for something after part of the job is done or after the job is done. If all you have is an invoice that shows the service that was provided and a price, there really is no terms to that agreement. There's no agreed on terms, and so you're going to be in the court enforcing default terms, which may not be where you want to be. And so if you're in, have a second page to your invoice that has some terms and conditions. We'll talk a little bit about that in a moment. Maybe if you have a recurring agreement with somebody, like this is a place that, for instance, the shred company that comes monthly to my place, a cleaning company that has a contract. Maybe you have a master agreement with a frequent customer or vendor, and then you have add-ons or invoices along the way that reflect your course of dealing as you go along. And then other things to think about are what is a writing? DocuSign is becoming very common. We use it in our business. How do you prove though if somebody shows up and says, that's not my signature, that's not me? How are you going to enforce a DocuSign? One way is to have someone upload, say, a copy of their driver's license as part of that transaction. So you can say, well, if whoever signed this on the driver's license has a picture, it signs in this particular location because it gets geographically stamped on DocuSign. But if you're not sitting with someone face to face and don't know who that is, you do want to think about additional ways to enforce or prove that contract if it is important enough to do that. Again, that's your cost benefit analysis. Is this a $100 invoice or a $2,500 invoice? All right. What needs to be in your contract is also something that can be very, very difficult to know if you've got the right language in there that's enforceable. So obviously, I've got this sidebar over here. If you're on your phone, hopefully you can see it, but certainly you need a price. You want to include dates of performance. That's price and dates of performance are probably the most common things that really get sideways. If something is taking longer than a customer expects, if you purchase something for your business that's taking longer to arrive than was expected, that's when you start to get frustrated. And so you want to have clear dates set out in there and perhaps contingencies if those dates aren't hit. Forum selection. A lot of people don't know what that is, but this, when you say you sign up for ESPN Plus because you want to watch March Madness on your computer, right? It's going to have a forum selection clause in there, which says something like, this will be interpreted based on the laws of Connecticut. And, of course, we all sign it. We don't think about it. But if you want to file suit, they are, you'd have to file suit in Connecticut about that. You're not going to be able to do that. If you're dealing with people who are out of state, which can be very easy, especially as we get towards, I'm from Rock Hill. There's a lot of Rock Hill and Charlotte business that goes back and forth. Do you need something in your contract that says this is formed in South Carolina and will be interpreted on South Carolina law? So that's where you are. Do you want to get called into court in North Carolina, Georgia, close by places, or if you're doing other out-of-state work? Liquidated damages is a term that you'll see a lot. That means that if the contract is not performed or if it falls through, that there's a specific amount that's set forth in there for the damages for either party. So, for instance, you could look at liquidated damages as limiting your own liability. This is how we talk about contracts limiting liability. If, say, you rent event spaces, okay, so you're gonna put a tent somewhere to host an event. Tent company doesn't have it, you can't perform on that. Well, so the wedding's canceled. It's raining. This is a terrible situation. Maybe you've got a liquidated damages clause in there. So if they do bring a claim against you, well, we've agreed that the damage is limited to the cost of renting the tent, which is, $500, rather than, hey, you ruined my entire wedding and I'm going to charge you for everything that's, all the vendors that showed up and all the flowers and everything that's ruined because we weren't able to hold it. Obviously, that's an extreme example, and probably that's not exactly how it would go down. But if you've got some term in your contract that sets forth specific damages that can help protect you. Same thing on the customer side. What if you don't get paid? And you've provided a service. So you've cleaned an entire business. They don't pay. If you have a liquidated damages provision in there, it may say if you refuse to pay us and we've got to go enforce this in court, then it's going to cost X amount. We've agreed on that up front in our contract that we signed. Arbitration is an interesting one. You see that a lot. Arbitration is in almost every contract. What that means is that you're giving up your right to go to court and go in front of a jury, and you're going to go in front of an arbitrator who hears both sides and puts a number on it. Arbitration clauses are very rarely written in accordance with the statute that makes them enforceable. Okay, so you might have that in your contract, buried on page 2, section 5, line A, and think that you're good, we're not going to court. It's not enforceable. The statute that governs arbitration in South Carolina says that it has to be in all capital letters, underlined at the top of the page on the first page of the contract. Oh. All right, so I've over the last several years, if I've purchased a car, I've purchased a couple of cars. The car dealer arbitration clauses that I've seen are almost never enforceable, so I happily sign those. The last time I went, they had a separate sheet of paper that said arbitration agreement. I looked at it and I said, goodness, they've got this right. And so I told them I wouldn't sign it. And they said, well, that's fine. There's one in the other agreement you're going to sign anyway. I was like, well, I'm happy to sign that one because I know it's not enforceable. But the point of that is you may have a clause in your contract that you think is covering you that really doesn't, because it's not going to hold up in court. Signing contracts, as an aside, I mean, do you know what's in your contract with vendors that you use? So we're all smaller businesses. We have contracts probably with much larger companies, national companies, to provide something or other, whether it's internet or we use a research-based platform. Do you really know what's in those contracts? Because even as a lawyer, a lot of times I'm just signing those things. Disney Plus was in the news recently because they were, I don't know if you saw this or not, but people who had signed up for Disney Plus, that had an arbitration provision in it that said it had to be brought in some other state, some northeastern state. And a family that had Disney Plus was in Disney World, had some sort of fall or injury incident. And because it was with the same corporate entity, Disney successfully argued that their case should be dismissed because it had to be brought over, in the Northeast pursuant to their arbitration provision that these people had signed up for to watch TV. So you may not know what's in your contracts. It is worth at least thinking through what you're signing as a business owner when you're agreeing to these deals. All right, so we've talked a lot about what should be in a contract and pitfalls. We've thrown out a lot of words that it's going to be hard to remember when you're going back and actually looking at yours. So what can you actually do? What steps can you take to make sure your contract or invoice or quote system is as good as it could be? So I've put a few here that probably ranked in order of both cost and efficiency, but certainly you could get a business lawyer to draft a template contract from scratch. Tailored exactly to your business, sit down with them, come up with a contract that you're going to use hopefully in each case that you have or each new customer that you have. One way to probably have a very good contract and save a good bit of money on that is to have a lawyer review a template that you already have. And so and that goes along probably with 3, obtaining a template contract from a trade organization if you're part of one. A lot of think about residential contracts that you use to buy a house. That's all a form contract that's sort of nationally put forth and then tailored to South Carolina by South Carolina lawyers. So you could get a contract like that reviewed by a lawyer. Hopefully that takes an hour instead of a 6-hour process, right? And save a significant amount of money. Probably the best way to make sure you have your contract set up the way you need to is to have it reviewed by a business lawyer. But getting a good contract from a trade organization that has been put together at a national level is going to be a very solid choice as well. And, that's usually going to be part of your dues for that organization. It's something that's been vetted. It's kind of like a one size fits all. So it may not hit all the bases for your business, but especially if you're a startup versus revisiting this, a year and a half in after you've got a client base and you're kind of rolling along, that may be a good way to save some costs and get rolling, knowing that in the future you're going to want to dial this in more and more particularly to your business. All right, so overall with contracts, I want you to ask yourself, does your current contract specifically outline what goods and services you're going to provide and the terms of the deal, especially a clear price and performance timeline? Like we talked about, price and timeline are the ways on things that get sideways way more than forum selection and arbitration, right? This is where the problems come up. So ask yourself if you're specifically putting forth what you're going to do for your clients before that comes up.
So if I could just challenge this real quick, it's just protect yourself. I've been blessed to work here. I was director of operations for 12 years. So, we do about 5,000 complaints we mediate. And once you have everything specifically in writing, it makes our job so much easier. It's a slam dunk. There's no questions about it. We move on. Even if the consumer's not happy, hey, that thing's answered. We're closing it. We're moving on. So protect yourself.
We had a couple questions, so I'll pause here since we're at the end of the contract section. These kind of, I thought, went together. They're a little different, but what should be included in a contract between a company and a homeowner? And then the other question is, what key elements should be included in a service contract to protect both the company and the client, especially in cases of non-payment or scope changes? So both of those, I think, are dealing more with company and a homeowner type of client, or not an entity, in other words, a solo person who we're talking about. And so in those, it's all well and good to say have a really detailed written contract that everybody signs. If you show up to do a quote at somebody's house and whip out a 10-page contract and want to sit down at their kitchen table and sign that, you may end up losing business just because that's daunting and it kind of seems like overkill. And so you probably have a quote, and I think that's a lot more protection for you as a business owner to reduce what you're going to do to a quote, even if you do it right there on the spot and say, okay, here's what you've asked me to do. This is the specific scope of the remodel or the roof that we're going to put on or the plumbing that we're going to do. This is exactly what we're going to do. Here's our quoted price. And if there are any changes to that down the road, it has to be done in writing. Otherwise, this document controls. And then actually follow through on those changes. Because, how many times do you see changing the color of paint or changing the color of the roof shingles or and whatever that is? You want to reduce the writing later on, which is hard to do because you're making these changes on the spot. But it really needs to be done to protect yourself from somebody arguing that you did not do what was put forth in the contract. Okay. And that way, if there's questions about what they are supposed to be doing, then you can show a very clear course of dealing where, no, we had a contract, they wanted to change, so I put that in writing, and that's how I do my business. And so now they're saying that we verbally agreed on something. I don't do business that way. If you're way down the road and you've been going along, making these changes along the way orally on a handshake agreement, and that's what you call the course of dealing of the parties, then that could be evidence to show that, well, yeah, you very well might have made another oral agreement, even though that's now where things have broken down. Okay, so those key elements that we talked about earlier are the ones that should be reduced to writing, and that will most protect you between company and homeowner. There's a question.
What other things should be in that other than price, scope, homeowner information, and the damage liability clause? Like, does it need to have a list of subcontractors that are coming in, or company X agrees to hold general liability insurance for the duration of the contract, or agrees to hold workers' comp for the duration of the contract? But what else should be in there?
So it's going to start varying very quickly between different companies. But do you list in there, hey, we're going to use X, Y, and Z specific subcontractor, or contractor reserves the right to contract out portions of this business.
Right,
to
that's kind of the
subcontractors.
question of what should that?
I would tend to leave yourself, as a business owner, to give yourself as general of a agreement on that as possible, unless the homeowner specifically requests somebody in particular. For instance, if you're talking about like car detailing, I've got one guy who I like to work on my car. And so if I was in a contract with a dealership to do some work on that, I would specify that, so-and-so detailing must be the one who completes the work on the exterior of this car. If I don't specify that and they just agree to detail the car and says that parts of this may be subcontracted out, I really have no leg to stand on if I don't like who they chose, so long as they do the job that was set forth in the contract. As far as insurance and things, you're required. We're going to talk about insurance, and you're required to have certain types of insurance. So unless that is a part of the deal, unless they're asking for that as part of the deal, I don't know that I would necessarily put that in there. You can put too much into your contracts. I remember one of the things that one of my contracts professors said in law school, which is really going to sound very on brand for lawyers, but they were talking about drafting commercial leases. And they said the goal, if you're the one drafting a commercial lease to lease out an office space, kind of like the one we're in here today, your goal as the drafter for the building owner is to make sure that the second that lease is signed by the tenant, they are in default. So that so that you can pick them out if you want to, and that you're already in the driver's seat. So part of what you're doing with your contract is deciding, do I want to put in, I'm specifically going to use these contractors, because if one of them falls ill and is unable to do it, and you get somebody who's just as good for the job, technically you're going to have to go back and rewrite that contract with your customer. Whereas if you just had a general clause to begin with, you could, you're more protected for your own purposes. So that was a good question there. And I think you had some other specific items in there, but that, you want to be specific as to what you are going to do, but general enough so that you leave yourself room to work. Okay. Probably very specific as to price, very specific as to timelines, especially if you're trying to give yourself some extra time. Less specific as to who is going to do the work, unless you're the one who's expected to do the work, or so on and so forth.
Gotcha.
Yep.
That's a question about signing.
Yes.
So most of our quotes and agreements are done by phone and email. So we have a specific quote that we email the client after talking to them on the telephone. Instead of signing anything, their reply, is that enforceable? They reply to your email to authorize the work to be done and agree to the terms?
That's going to be one of those cost benefit things. I personally am fine with that. I'll do that in some cases. But if we're talking about a 5-year cleaning contract with an entity, that's probably a sit down and make a contract. If we're talking about a homeowner, where if there starts to be non-payment or something like that, and you can get out of it having not lost too much, then you're probably fine with an email that shows the agreement.
Yeah, because ours are not binding as far as the length of the terms of their service.
Yeah,
it's just
sure.
Like, we want you to come in bi-weekly, but they can cancel it anytime.
Right.
So, and then what about phone? We'll get a credit card over the telephone to charge their accounts, and we usually send an email saying, do you authorize us to charge? And they'll reply back. But then every now and then you'll get somebody who doesn't use email, and they want to call, and when our phones are recorded, our calls are recorded. So is that authorizing us? We ask the same question.
Yep, that's probably fine, but that's one of those where you're going to be in a better situation if, even though it's a pain, if they don't have an email where they can authorize it, if you have a written form where they fill out their card information and check the box that says I authorize the card to be charged, which we probably all. And some of those things are pretty specific. I'm happy to talk more about that as well. Okay. And then I had a question about engagement letters and having how to word an engagement letter to provide adequate protection. That's, an engagement letter is probably something that is going to be it sounds like that's either touching on close to a fiduciary relationship, or at least something where you're providing a service that's very tailored to a specific company or application. And so the biggest thing that I would want to see out of an engagement letter is that you're setting forth exactly what you're going to do and having them countersign that in some way. A good example of that is my accountant. When they send me the business taxes at the end of the year, there's a cover letter that says we prepared these based on the information you sent, and we're going to submit this electronically with your signature, with your approval. Sign here and scan this back to us as part of your package, and that that would form kind of a meeting of the minds in that contract. So, but again, an engagement letter, any type of letter like that, I'm probably going to want to get reviewed by a lawyer specific to my application to at least have a template that you're working off of. All right. Going to move along. We're going to zoom through insurance a little bit. But so talking about liability protection and especially insurance, nobody wants to buy insurance, right? It really just feels like such a waste of money every year.
I get about your family, Joe.
I get my car insurance bill and it goes up every year, which everybody blames on me, but it's actually Allstate's fault. Happy to talk to you all about that another time. Okay, but you got, it's one of those things that you have it, it's a backstop. If you don't have it, it's a nightmare. And so you have to pay the Pied Piper. But choose it. So it's really a foregone conclusion. You need insurance. The biggest problem that people have is they buy insurance and then it doesn't cover what they think it covers. So I'm going to talk about, I really want to spend my time on insurance talking about that because we're a little crunched on time because contracts was so interesting. So, but the biggest mistake I see, and I see this in my business because I am bringing cases usually on behalf of individuals against insurance companies and entities, and it's somebody who thinks that they have the right insurance, but they don't, and that is particularly devastating. So a good example is a case that I brought right now. It's down by the coast. My client was on a boat that was operated by a commercial oyster company. Okay, and there was a boating accident. The client is seriously injured, and so we're so sorry. Here's our insurance company. They contact the insurance company, and it has an exclusion for operating a boat. Now, again, this is an oyster fishing company. Their insurance policy excludes boat operations. So you have got to read your insurance policies to make sure that it's covering what you think it does. I have a million horror stories like that, and I've been on both sides of them, both looking for coverage for a company, suing the insurance company for them because they bought a policy that was sold a bill of goods that didn't cover them, and being on the other side, finding out that this person who we're bringing suit on behalf of, this company's insurance is not going to kick in. So it's not a situation that I want to be in on either side. But so here's some common insurance policies you might need, and some pitfalls with all of them. All right, automobile policies. We all think of liability. We know everybody knows you're required to have 25,050 in coverage. That means 25,000 per person. If you hit somebody, no more than 50 total. That's not enough insurance for probably anybody in this room. I would recommend getting at least 100, 300 policy if you can. It's really not that much more, and it gives you a lot more coverage. When you're thinking about how much coverage to get, you want to think about how much you're protecting. You're protecting your own assets. Okay. Now, I will say I've never seen, maybe one time in an extreme case that has no bearing on anything here today. I've really never seen anybody get their personal assets get attacked out of an automobile accident, but you don't want to get that letter that says, so-and-so has permanent brain damage and they're on a ventilator for the rest of their life, and you get a $25,000 policy. Okay. Other insurances that you should buy on your policy. Everybody has what's called UM coverage. That means uninsured motorists. So if the person that hits you does not have coverage, your own insurance policy is going to kick in and cover that. Not everybody has UIM. A lot of people reject that. And you should go look at your policies today, business and personal, if you drive for your business, and make sure you have underinsured motorist coverage. That means if the person who hit you did choose to have 25 and you can't even replace a vehicle these days for $25,000,
No.
right? So you need to have your own underinsured coverage that's going to kick in and cover that difference. You can reject underinsured coverage. You can't reject UM. And my parents rejected their UIM coverage, and I got on them, and we fixed that. They said, the policy was something like $1,000 for 6 months, and then you can add on UIM coverage for $36, and they rejected it. Come on, this is not where we're going to save money, guys. So do buy the UIM coverage. You're able to buy it up to the limit of liability protection that you have. So you can't buy yourself more underinsured than you bought liability to protect people you might hit. You can get those limits equalized, and that's important to do. Another thing that you really need to have is make sure that all of your cars have UIM coverage. Because if I buy UIM coverage on 2 out of my 3 cars, and I'm driving the 3rd car that doesn't have it, and I get in a wreck, I'm out of luck. Okay, so have it on all I would rather you get 5,100 on 3 cars than say, well, this is my daily driver, I'm going to gamble and just get 100, 300 on it, and then get in a wreck when you're in your weekend car. All right. Automobile policies usually exclude things like ATVs, golf carts. Personal policies exclude business operations. So if somebody's driving for Uber, their personal policy does not cover it. Business policies exclude personal use, right? So look at those exclusions. Certain types you could be using your car like a work van or something. You want to make sure that if you're using it and it's a business application, that you have it covered under your business policy. Because if you just are relying on a personal policy, it may exclude it if it's used primarily or only for business, right? So make sure that your policy does cover what you think it does. We all know about commercial general liability and business owner policies. They usually exclude the use of an automobile. So that doesn't cover your autos. Like I said, with the boat example, they can exclude coverage you think you have. Another example, I represented a company that was a construction company doing a very large project on an oil line in Canada. And they were constructing a very large utility shed that blew down in a hurricane before it was completed. And their insurance policy only covered completed operation, not things that were in progress. So that argument became, well, when is it complete? Okay, so they didn't have under construction coverage. They only had post-construction negligence coverage. Usually a business owner policy is going to exclude professional negligence. So I have both a business owner policy and a lawyer policy. They both exclude everything that the other covers. All right. All of those are going to exclude injuries to employees. They're only going to cover acts or omissions to people outside of your entity. So you're going to have workers' compensation coverage, which I have under the statutorily required line. It's mandatory if you have 4 or more employees. All right. It is not liability insurance. And so if you have workers' compensation, that's not going to cover if you're working at somebody's house and they drop a hammer on the homeowner, that's not going to cover it. It's for your employees getting hurt. It is not, are you required to have it? You need to think about W-2 employees versus 1099s. You also can't have all your employees be 1099 or independent contractor to avoid it, because there are cases that cover that. So really you get into, you do see that a lot where people have something set up nominally as an independent contractor, and they think if they pay their employees weekly and have a contract with them, that makes them an independent contractor, but they're wearing a uniform with XYZ company on it. You give them all their tools, you give them a vehicle, you tell them exactly how they have to do what they're supposed to do, and you hire them and have the right to fire them. That's an employee. That is not a contractor, even though you have all the disadvantages on the business side of paying them like a contractor. Okay, so you can't avoid workers' compensation coverage just by setting it up as an independent contractor. If you're going to use contractors for your business, especially for most of what you're doing, you can think of a cleaning service. If you have contractors, if you've got a plumbing service and you use plumbers that you're hiring as contractors, they need to have their own tools. They need to provide their own transportation. they're really operating as their own business under your business. So other statutorily required coverages are for alcohol service. That's one that was a law that was passed, I think, in 2018, Emma's Law, that requires coverage for bars and restaurants that serve alcohol. Previously, that was not a rule. And then commercial motor vehicle, which may or may not be applicable to any of y'all, but those are statutorily required coverages.
Two quick things.
Yeah.
First one was on the 1099s. I had heard something about also along with that, they have to provide their own tools, insurance, etc. You can't use them for more than 60% of what you do. Is that
So
there's a certain percentage in there that you can't use them every day?
it's really a sliding scale, and it's all these factors that were laid out in the case. The name of the case is actually WHAM versus somebody. So lawyers just love to get up and argue the WHAM factors because it's a fun thing to say, but it's all a sliding scale. And it's like how, okay, they have their own tools, but the biggest one is the right to hire and fire them. So if you can tell them you're fired and they're out of work, then
Well, you can do that
that's
to
an
any
employee.
contractor.
You can fire a contractor, but if you fire them and they're out of a job, they were probably your employee. Probably. Okay. But again, it really is a sliding scale. All right. Employment practices are generally excluded. We'll talk a little bit about best practices in employment in a minute, but there are separate employment practices policies, or they're subject to a lower limit under your commercial policy. So like mine, I think, says that they'll pay up to $25,000 for, I have $1 million business owner's policy for negligence, but it's cut down to $25,000 for employee claims. And so if you're worried about that, then you can get employee insurance that sits on top of that. Errors and omissions policies, generally that's going to be if you're a professional or fiduciary duties in your business. They're going to exclude other business operations. Property and casualty is an easy one to get tripped up by. It's often you might be subject to a contract that requires you to have that insurance, like a mortgage, most leases will require you to have protection on the property. So make sure that if you have those, you have the mortgagee or the protected company listed in your insurance contract so that you're in compliance with those. A lot of policies exclude premises that you own or rent, depending on what type of insurance it is. So if you own a building and you are insuring it for loss with a mortgage, with a mortgage company, we own our primary building, but we lease a space in Charleston. That policy is going to exclude if the place in Charleston that we rent burns down. It covers if our building burns down. So just know what you're actually covering. And then a big one that's coming up lately is cyber liability. Everything for many, many businesses now is stored in some sort of server, whether it's with Amazon or Microsoft or even Dropbox locally. If those things get taken and you can't get your business back, or there's a ransom payment for it, or liability to your customers for losing all of their personal information and social security numbers, a cyber liability policy is really the only thing that's going to cover that. They are very expensive for what they actually cover. Almost cost prohibitive at times. So it really depends on how much information and how much of your business is online as to whether you need that. But certainly consider it, because that's another lower limit or exclusion from most business owner policies. And then an umbrella policy, that's a catch-all. It can be a personal umbrella, it can be a business umbrella. But those sit on top of most policies. But again, you have to know what it sits on top of. It doesn't sit on top of errors and omissions usually. So know what you're buying. Maybe you're comfortable with your umbrella policy. Usually that's a much larger amount. So oftentimes a commercial general liability policy is $1 million. That's kind of the standard number. And it's really hard to think of something so catastrophic that it's over that. But so an umbrella policy is usually very comparatively cheap for what it covers, but it might be $5 million on top of that million. they can offer it pretty cheaply because they never actually, their exposure only kicks in after what would have been an enormous claim on the bottom level, but it does sit on top and protect you. However, if you've got something like an errors and omissions policy that is not covered by your umbrella, you might want to have, say, a $2 million E&O policy, just so you have a little bit more room and you're not, subject to personal liability after the underlying limit. Just food for thought on that. Also wanted to say, this was one of the questions. If you store business inventory at home, like in your garage, that's a common one, that may be other premises that are not covered under your property policy, so your business property policy. So, if I'm storing a bunch of lumber at my house and the garage burns down and now my carpentry business can't fulfill its obligations, well, that business policy I have is not going to cover anything to do with my house or property I lost there, most likely. And so, you want to think about how you're using your premises and how, whether that's covered adequately for what you actually have there. All right, so boil it down. You might be required to have certain types of insurance under the law, like workers' comp, contract you have, or some other agreement that you have signed. Your insurance, even that you have now, may not cover what you think it covers. So sit down with your agent, have an agent who does what you do or who knows what you do. I work with an insurance agent who specifically works with fiduciaries and lawyers and accountants. If I had like a trade business, I would work with somebody who actually works with businesses all the time. I wouldn't just go to my buddy who does my car insurance and does a great job with that and say, hey, can you go on the market and purchase me a commercial policy? Because he could, but does he really do that day to day and know what I need? So I want to form a team that actually covers each specific instance. And then notification provisions are a big one in your insurance policies. So if you do rent a new location, if you hire new employees, add them to your workers' comp policy, adequately report things to them. Like if they require you to tell them how much money you make per year so they know what type of risk you're insuring, don't let them put away and just turn in the same application every year. Easy to do. The business goes from $100,000 revenue to $200,000 over a few years, and you just keep copy pasting, the date 2024, 2025, 2026. Before you know it, you're accidentally turning in an insurance application that is wrong, or they would say fraudulent, because you're really just not paying attention to what you asked for or represented. So update that every time you're applying and make sure your agents know as your business grows or shrinks your different needs. All right. So the final, ask yourself, am I sure that the insurance I've purchased covers the types of exposure I have from my business and any other risk I'm required to insure against? So looking inward and then anything you've agreed to cover. All right. I know we're getting close to the end of our time. We had an insurance question. I think I covered, is there any other insurance besides general liability and workers' comp a business must have? Minimum coverages a company should have for an automobile for the company. That that is going to vary a little bit based on what you're doing. But I think most business auto policies are going to be more they're going to be hundreds of thousands, not the 25-50. Okay, so it's probably 250, 500 is the most common thing I see for a small business operating maybe a work truck or a couple of vans or something. At some point, if you have multiple vehicles, there's really not a whole lot of difference in the premiums between that and a much larger policy. And so you need to be talking with an insurance agent who handles fleet vehicles and things to really adequately cover yourself there. Good. All right. Any quick questions there? I want to get to the next things. All right. All right. Employment law essentials. How are we doing on time? Good. All right. Hiring, firing, and employee policies. This is going to be a very broad overview. And I'm going to reiterate my little disclaimer from the beginning. This is not what I do for employment. When I get a bunch of calls from people about employment questions, usually individuals who are, upset about something that happened at work, and I refer them all elsewhere. I don't handle it. I don't do it. So this is all kind of from my perspective as a business owner, trying to protect myself from employee claims. All right. More so what I think is the concern of most people on this call. But we're going to talk about hiring first. Know what you can and can't ask. So there's these protected classes that like age, race, ethnicity, gender, sexual orientation, religion, marital status, pregnancy, disability status, family plans. You can't ask about those. And those come from protected classes from actually generally Supreme Court case, like U.S. Supreme Court cases that have been filtered down into if you can't discriminate based on age or race for purposes of education, then state and local federal courts will apply that way. You can't discriminate at a job. Okay. And so that is how that has all filtered down in these various protected categories. But things that you may not think about, like you wouldn't want to be sitting in your interview and ask, have you ever made a workers' comp claim, right? Or an employment claim. These are things that you can find out with a background search, with a public index search. A lot of times on the court record site, it's really not good interview fodder. You also, another common example that we all hear about is you can't ask, do you have a car? What you can ask is, do you have reliable transportation to get to work? And so you really want to be careful about how you're asking questions. And, these are things that I guess you could think of like some really bad actors who might be asking questions to try to discriminate. But these are also things that you could just genuinely accidentally blunder into in an interview. Like, for instance, my wife was, we have 3 kids. So she was pregnant 2 years ago, I guess. And I think she was at not an interview, but she was somewhere and was asked, when are you due? And so you really wouldn't want to ask, when are you due, if you're in a interview meeting, because that could be toward the pregnancy things. And then if she didn't get the job, well, they were concerned about pregnancy. They specifically asked about it. So don't, just try to stay away from these areas if at all possible, unless the applicant brings it up naturally in conversation. If you're going to have preferences or prerequisites for a job, I really strongly like the word preference better than prerequisite, because prerequisite just automatically implies that you are not going to hire somebody who doesn't meet the requirement. But if you require an associate's degree, or you want somebody who has 5 years of experience, go ahead and list that as a preference for the job. If you post it on Indeed or something, which I've used, many of you have probably used. You can consider, so a lot of people do offer letters. Offer letters are tricky. I like them though. Consider setting out the specific terms of an offer in writing. Salary, payment structure. How are you going to pay them? We do biweekly at our office. Some people are coming from a bi-monthly schedule, and even though I say biweekly, then the question comes up, where's my paycheck? Like, oh, well, we're every 2 weeks, not the 1st and 15th. Are you going to, if you have a bonus or commission structure, very clearly set forth how they're going to earn that, and make sure, so this best practice thing, if you're going to write down one thing, I would put in the letter, this letter does not create a contract, or something like this. It doesn't create a contract, but it's intended to help summarize the position and for your information. Make sure to say your employment will remain at will. That's in all of my letters when I offer, attorneys, paralegals, and office staff jobs. You want to make sure that you don't accidentally turn them into a 1099 employee or create a contract through your letter that has no termination date in it, so that when you do terminate it, you have then ended the contract. And the question is, who breached the contract? So don't make a contract. One of the worst things you can do, and I think, I'm going to see if I talk about this next here. All right, one of the worst things you can do, this straddles both this slide and the last one, is to have some sort of bonus structure or commission structure. If you haven't outlined it very explicitly, and then they think they've earned it and you don't, and it becomes a court case, the wage payment statutes for withholding wages in South Carolina if an employer is found to have wrongly withheld wages, can be subject to 3 times the damages plus attorney's fees. So if you owe them a $5,000 commission and they win that argument, it can easily be 15 plus their attorney's fees. So withholding wages, and that gets into, I'm getting a little ahead of myself, but if you hire somebody before your business is able to take that on, you don't have reliable cash flow or reserves to cover that for a reasonable period of time. If you can't make payroll, that's a wage payment claim. So you're in the same boat. So don't hire somebody too early if you can't make payroll. Make sure to specifically set forth whether they're an employee or an independent contractor, and then act like it with like the factors that I talked about earlier. That is something, if you're using contractors and want them to be contractors for workers' comp and liability reasons, then you really want to review that with a lawyer. That's something you don't want to get caught with the court deciding for you under the factors. And then best practices, have an in-person interview so you meet somebody. Now, I've hired people off Zoom, so I'm do as I say, not as I do, especially a few years ago. But check references and consider a background check. We've probably all, at some point, or most of us, been lazy with checking references and wished you had. And again, don't hire if you can't make payroll. All right. Now, firing.
First, you have to have a contract to hire somebody.
No, not at all. South Carolina is an at-will state, and so you don't want to have a contract in most instances. You want your letter, your offer letter, to say this is not a contract. It's just a summary for you, so you can go back and look at it later and remember what the offer was. All right, so firing. I hate talking to people about job performance, let alone firing somebody. And I almost always chicken out and come up with a improvement plan. Okay. So, which maybe
they hate their job so much.
Yes.
Oh man. So my first bullet point on firing, you can tell what a chicken I am. I say consider whether you think they can improve. Set out some metrics and timeline. Part of the reason though is to set that up. You can't just get frustrated, and we all do. We get so mad, like they're always late. They do a terrible job. They don't answer the phone. We're missing calls. And finally, one day, I'm so fed up. I'm like, just go home, file for unemployment. I never want to see you. Set forth those metrics, not just because give them a chance as a person to get better, because they may actually respond to that. But you've documented for yourself that you have set out some specific targets for them, given them a time to improve, so that when they do file that unemployment claim, potentially it might be denied, which you might be glad about. Document things. So tardiness, specific issues that you're having. I hired a paralegal one time who wouldn't answer the phone, which was just shocking to me. Just would not answer the phone. Said it was broken. Which it was ringing. Why?
It was making that noise.
It was ringing at the same time. But so. Document these reasons, put them in an email to copy the person and your HR person. One of the best tips that this is not my tip, this is the tip I got at an employment law seminar for lawyers, was either give all of the reasons for firing or no reasons for firing. And they said no reasons is usually the best, because unless you think of everything, or maybe some of your reasons are not ones that would stand up very well. Maybe you just don't like the person. Either give them all the reasons or no reasons. I'm on the no reasons. That can go sideways really quickly too, because they're going to ask, why am I being let go? You say, well, you just wouldn't answer the phones. Well, now you've given a reason, not all the reasons, and you're back in trouble. So just no reasons. We're moving on. We're separating ways. That always just pay them everything they're due without any unapproved deductions. So don't, maybe you forgot to set up their health insurance deduction out of their salary. Don't put it on their last one, right? Don't go fix it then because you're angry. Pay them their last paycheck as much as it just is going to grind your gears to do it. Don't want a wage payment claim. and never withhold payment or employee property. Have a nice clean break. Okay. And then finally, a handbook. If you've got a handbook, make sure it's up to date. Give it to everybody. Have them sign the disclaimer on the first page stating that it doesn't form a contract. Make sure and that will also satisfy having signed the employment handbook. It doesn't have to be signed, but it's great to have their signature on it so that they can say, I got a copy of this, had a chance to review it. Okay. And don't treat anybody differently or arbitrarily enforce policies. A great example of this is we have a 10-day vacation policy at our business. Okay, I have some just all-star employees who, I mean, they probably use 8, and I'm really not sure why they don't take the extra days, right? I want them to. And then I've got people who are on their 12th day already, and they're taking unpaid leave. I'm wondering why I didn't allow that. But so the employee though, once all-star employee gets to 10, I do need to make sure that even though I'm totally fine with them taking an extra day here and there, I still want them to email me. I want to say that's an approved. I want them to email me, email payroll. I want to say that's approved, and then if I want to handle that some other way and give them a bonus at the end of the quarter or end of the year, then so be it. That's a separate transaction, but I've treated everybody the same on their payroll. All right. And oh gosh, don't go download a template policy book online and go set yourself up for saying like we comply with FMLA guidelines for leave, and you've got 8 employees, and all of a sudden you're subject to, you can go download it today, a template HR manual, and you have just subjected your little business to FMLA leave policies and pay policies and insurance requirements. And I mean, well-intentioned, you had a choice to download the 2-pager and the 50-pager. Well, more is better. Right? No, don't do that. So have your handbook reviewed by either an HR professional or an employment lawyer to make sure that you're not doing too much. All right. So the ask yourself portion for employment law is clearly set out the terms of employment during the hiring process, and then document any issues or discipline along the way in preparation for a potential termination or a defense of their own claim against my business. Business structure, liability perspective, how you set up your business can be very important. So many people get into business, and they, by default, if you just go open up shop, you're a sole proprietor. If you don't do anything, you don't file anything, you're a sole proprietor. Lots of great businesses and very successful businesses start out that way, and so it's fine. But there's really no need to just form an LLC. Even if you just go download the forms yourself, fill yourself out as the only member of it, and send it into the Secretary of State. An LLC, I'll talk about a little bit, but it's going to be mostly what everybody would want, with some exceptions. A sole proprietor is just you. So, your own insurance is going to apply or not. It may exclude you if you're doing business purposes, but trying to use a personal insurance policy, really not a good way to go. Some companies get gigantic just as sole proprietorships, and just without anybody even thinking about, there's no governing documents.
You do not believe how many we see. I see it every day. I'm amazed by it.
And those people are just out there floating in the wind, subject to personal liability. Could have just filed a form. So partnerships are pretty outdated. They are almost exactly like an LLC, but they don't have the liability protections that the LLC statute gives. So LLC is a great vehicle to limit personal liability. You just have to file the initial paperwork to invoke it. It typically limits your own liability for claims against the business that arise out of business operations. And then you can elect different types of taxation depending on what's beneficial to your business. I'll let you discuss that with your accountant. But it does free you up to a lot more options than sole proprietor and partnership. And then a corporation is usually, that's going to be a larger entity usually, or some sort of family-held entity where you need to have different shares allocated, even though you can accomplish that in an LLC. Corporations are more complicated ongoing because you have to make filings and observe corporate formalities like having shareholder meetings, you have to maintain a board, You have to have officers elected, and if it's a small, closely held organization, those things get sloppy really quickly. And so probably should just have an LLC unless there's a specific reason to form a corporation, which you would be doing with a business lawyer. All right. Keep your filings up to date with the Secretary of State. So if you add or delete a member or a folder, file the appropriate documents. It's pretty easy to add them, but if you don't file the documents that add them, then you're in a mess legally if things go sideways. Do observe corporate formalities if required, like with a corporation. There's very little with the LLC that's required. If you close your business, get somebody to file articles of dissolution or do it yourself. I'll just mark it closed on Google and figure that shop's closed up. And then big one, do not form an LLC. So you've got all these wonderful liability protections. You're not subject to personal liability. And then I go out and do business as Thickens Corporation. All of a sudden, I've represented to everybody that I'm a corporation. I don't have the same liability protections, or even worse, Joe Thickens Legal, right? That has no indication that I'm a limited liability company. You have to hold yourself out to the public as a limited liability company. The rationale being that they know they're dealing with an LLC or a limited company when they choose to do business with them. If you didn't choose to do business with an LLC, then you may not be subject to the protections that gives. There are different tags that you can use. So I know the LLC is one, LC, L.C. You can decide how you like it to look on your business card by yourself. And then that should be a discussion that involves both your CPA and legal team, how to set up your business. All right.
Can I ask a quick question?
Yes.
So if you're an LLC, but for tax purposes, you want to file as an S corp, you do the paperwork to file as an S corp. Do you maintain that LLC on your?
No.
You maintain the LLC protections from a liability perspective, and you are under the LLC statute for purposes of what filings you have to have. But you file taxes as an S corp, and that's an accountant. That is a work with your accountant question. But it does change your structure a little bit, because in an LLC, when you first set it up, you're going to allocate percentage ownership to the members. When you become an S corp, you're going to have to give shares to the members, which can be the same percentages, but you do have to make sure you observe those formalities the right way. If you're a solo member, it's probably not as big of a deal. But I would still talk to the accountant.
Thank you.
Or if you do your taxes, do even a one-time meeting with an accountant to make sure you're doing it right, and pay their hourly rate is better than just probably getting it right.
Thank you.
Yep. And then if you do elect it, whatever you elect, don't let the shield go down by not observing the formalities. So we call it piercing the corporate veil. Let's see, where am I? If you mix your business and personal finances, so a lot of very small businesses, you see, it's just their checking account. It's just somebody's checking account. And they're running their business out of it, buying materials and paying their light bill and Amazon out of the same account. Have two accounts. Do not commingle business purchases for personal use. That is very fuzzy and muddy for everybody, but try to keep it very well separated. Or at least, if you've got something like that, separate autos, for instance, you get a lot of people in trouble. Have a specific percentage that you can support, that you say, I use my auto for 20% business purposes and 80% personal. And don't get aggressive with those things. It's really not worth the savings. Be very, very careful with what you claim as a business purpose. So if you do fail to observe those corporate formalities or let things get muddled, then the courts will just treat it as one big pot of assets, and then suddenly your personal assets and your business assets become one if something goes downhill. All right. And final point there is ask yourself, this is a really good thing to ask. Have you chosen the type of entity that best reflects what you're doing with your business and shields you from personal liability? And then are you carefully following the rules that you have to make sure that will stand up? Okay. All right. Somebody, there were some specific questions about personal or about intellectual property. And so the biggest thing that you need to know about that, and if that person is watching, intellectual property is probably one of the most specialized areas of law. And so whatever intellectual property you are trying to protect, you have got to talk with a very expensive patent or trademark lawyer about that. Whether it's your logo, your tagline, a specific product you have, or a specific system you have, that is usually done by somebody who both has like an engineering, medical, or other type of specific degree and a law degree. So these are, these are people that I did not hang out with in law school because I wasn't smart enough. But you really need to go and protect those things in great detail. One of the big examples around here is University of Southern California sued University of South Carolina for the USC logo.
It eats me up, Joe.
And we were formed in 1801 before their state was in existence. It doesn't matter. That case was brought in the Southern District of California. Guess who won?
Oh, yeah.
Okay, so protect your marks. I know I am friends with a business owner who had started a business here. It turned into a very successful business. They are now franchising out parts of the business. And just online one time, they found there's a business in Washington that has the same exact name. Neither one has any idea that the other existed until that happens. And their attitude towards it is there's enough separation. There's some geographic things that come in there. So they're not really worried about it unless their business expands out west. But if it was a business that was up in Charlotte and we're in Columbia, that all of a sudden becomes a fight. And that go back to the USC, U of SC now example. You want to file that case in South Carolina, don't let it get filed in North Carolina because the home field is probably going to be a pretty big advantage in this situation. Hopefully the court's going to look at it and whoever wins, should win, wins. But I would rather get South Carolina business. Okay. That is a very, very complex process. I've registered a couple of copyrights and logo. Even you've got to have schematics and drawings. Somebody who can actually put those in with not only the shapes and fonts, but also the color schemes. And so it is an expensive process, but if you need to protect a mark, it's definitely worth doing. There's somebody in Florence right now who's using my firm's slogan, and it's not registered, so I can't do anything about it. But I'm flattered. But it's if you don't protect it, it's out there for anybody to use. All right. One of the famous ones is Xerox. Very aggressive about protecting. You can't say in writing or in big public forums, I'm going to go Xerox this paper. They will send you a letter. If they find out about it, because they're protecting that mark. If that just becomes an adjective, it's free reign. The Kleenex is one that I think they might have lost or come very close to losing. You pull a tissue out of any box that you got from anywhere, I'm getting a Kleenex. That's just a noun now. So anyway, all right. So have you registered your logos, products, and systems to protect your intellectual property and have a plan in place to guard against losing them? So are you not only registered it, but you see somebody infringing on it, are you sending them a nasty letter from your lawyer? Okay. I'm happy to answer a few questions. Probably got 10 or 15 minutes to do that if anyone has any.
I have a question.
Sure.
When you were talking about the employee handbook, and remember, my people are 1099. So one of the things I just want to make sure is clear that I'm doing it right. The first page, like you said, kind of say, hey, this is not a contract. It's just summary of the way we like to do things here, and the expectation for when we're catering to clients and we have clients in the venue and stuff. Is that still okay to have that and then just sign a statement of understanding?
That sounds fine to me.
Okay.
I think that you want to be careful of in that instance is if you've got people who are just always working for you, and the question becomes not just do you have a set of expectations, but do they wear a uniform that has your company on it? Do you have all of the equipment that they use and everything that they're doing to perform their job? How do you pay them? Are you paying them per job? Or are you paying them a salary? Those are all questions that weigh into whether they will stand up as a contractor. The other thing you could potentially do to maybe shore that up a little bit would be think about making it if they're an independent contractor, when they contract with you to do a job, if every job this is how we're going to do this job, and assign our expectations for you as a contractor. If you've got one thing that they signed at the beginning of the relationship, that's probably fine, but it depends on how the rest of it is structured.
So I have questions that surround like holding companies and different entities. Is there someone in your office that's kind of a specialty that I could speak with?
So we don't actually practice in that type of law, which was one reason I was happy to do this seminar, because I got to rush a little bit. I'm trying to get business from it. But Chris has some people, some members of the DGD,
Absolutely.
who he can recommend, and then I'll pass some people I know who do corporate law along to him, and so he's kind of the resource for that. But
it's got some great folks.
Definitely a great question, and worth sitting down with somebody.